just by sort of real brief, just by really brief way of intro. So I'm Marty Gomez. I'm a partner at Goodwin, IP practitioner, but I kind of come at these issues from more of the software side of things. I more sort of focus on sort of the AI piece of biotech and AI. And Olivia, do you just want to introduce yourself quickly?
Yeah, happy to. Hi, my name is Olivia Uitto. I'm a partner in the same group as Marty. So we're in the life science practice group at Goodwin, and we're both patent prosecutors. So we write the patents and kind of advise on IP strategies. Like Marty said, he's more on the tech and kind of software side, and I'm more on the therapeutic side. So my background is I have a PhD in chemistry. So I mainly work with patent strategies around like the therapeutic space. So like small molecules, antibodies, bispecifics, gene therapy. So what is like actually administered to the patients?
Awesome. So as you can tell, Olivia and I sort of team up quite a bit on these types of issues, given sort of our kind of the different aspects that we come at it from, and hopefully we'll get into some of that today. We're going to get into the weeds a little bit later in the presentation, but just sort of like at a high level, artificial intelligence is not especially new. I mean, sort of in sort of connotations of it have been being discussed for decades. Frankly, many software companies, the companies that sort of initially were sort of building some of the initial algorithms or models around artificial intelligence, have been doing it for quite a long time. There's been a lot more sort of public attention on sort of the space recently, given the launch of some very popular sort of publicly facing tools like ChatGPT and others. But artificial intelligence is something that in the software space has been looked at for some time now. What is really kind of new, or what we've been sort of witnessing the last couple of years, and what Olivia and I have been speaking about quite a bit, is the life sciences space is sort of historically and traditionally sort of a wet lab space, right? Sort of a lot of drug discovery and development is done in petri dishes or forms thereof, sort of in scientific labs. And, obviously, what we've been seeing is sort of the infusion of software and AI into that traditional space. And that's been creating, frankly, some novel legal issues that the life sciences space hasn't really had to confront before. And that's part of what we will discuss in today's presentation. We are seeing sort of, this is at a very high level, a very sort of, crude sort of generalization of sort of the different ways that life sciences companies are incorporating AI into their businesses. But I think it's helpful to just kind of, I guess, frame the discussion. And, we will, as we sort of understand these different business models, we'll talk through some of sort of the business and deal points that come up through them. So two main models, right? I mean, at the end of the day, AI, again, very crudely, right, takes in a bunch of inputs. Those could be, different molecules that a company has in its library, or maybe different targets that it wants to sort of, bind something to. The AI acts on those inputs, and then it comes up with an output, either a design for a molecule or a design for a drug that can, bind well to certain target sites would be a good example. Many other examples as well. But that's what's happening in AI. The difference in the business models is sort of, what are you commercializing? So we have sort of what I would say is more sort of a traditional life sciences company, which is sort of just using AI as a tool internally inside the company as a way to sort of help them, maybe develop a molecule or a therapeutic or something that's going to commercialize. But they're planning on commercializing the outputs at the end of the day. So that's one model, and it looks sort of kind of very traditional as far as sort of life sciences companies are concerned. The other big model, and this is new, and where sort of a lot of different kind of considerations come in, especially given traditionally how life sciences companies have operated, is you're not so much commercializing, either the inputs or the outputs, but you're commercializing sort of the AI itself, right? And even though these companies don't often want to be sort of referred to this way, in this context, we can sort of describe them as sort of like offering the AI service provider, right? They are providing the AI. They've developed this sort of algorithm, and their customers are giving them inputs, and then they're delivering those outputs back to their customers. And those are the types of kind of companies that we're seeing a lot of. And we'll get into a little bit sort of the different, I think to be able to understand kind of the right IP strategy for each of these different models, you need to know a little bit more about the different types of IP, particularly about trade secrets, which is historically not super common in the life sciences space. But before we get into that, you know, there's just some interesting things to sort of think through when it comes to if you are one of these companies, how do you sort of structure your customer arrangements? How do you sort of structure deals that you enter into? Because ultimately, and we'll talk about this, sort of the way that you sort of protect your IP ultimately has an impact on the types of economics and the types of deals that you're doing. So just a couple of things to sort of think about, and then sort of we'll get into some details on what this stuff means a little bit later on in a few more slides. But, if we just look back for a second, right? So let's just keep that sort of bottom business model in mind, right? You've got a company that's sort of an AI platform provider. Let's call them a platform provider, right? So who, if you are that AI platform provider, who should be able to sort of own ultimately the IP that comes out of that AI? Is it the customer that gives you sort of the inputs, or is it you, sort of the service provider that uses your tool to develop the output? I can tell you sort of historically, right, that if a big pharma company goes to an AI service provider and asks them to, sort of act on their data and to come up with sort of a design for a molecule, historically, the life sciences company, that the pharma company is going to want to own the outputs. They're going to want to pay the service provider as a pure service provider, and they're going to want to get ownership in the IP that comes out of the model. But, the service providers, the AI companies, the types of companies that Olivia and I work a lot with, the economics there aren't as good as maybe if you have sort of a piece of sort of the ownership of the IP that algorithm sort of develops. So something to think through, right? Who's going to own the IP? And then are there going to be licenses granted? Is the AI company going to grant a license to the customer? Is the customer going to grant a license to the AI company? Or is the AI platform company simply going to be a service provider? And then, other things to think about, right? So a lot of times, right, these AI models will sort of work on, lots of different data, and they might come up with lots of different sort of compounds or products. And, maybe only one of them sort of meets the customer's requirements, and they deliver that, to the customer. What about all the sort of compounds or products that, sort of the algorithm, acted on that are either discarded or not given to the customer? If there's some obligation to delete those, does the AI service provider get to keep those and potentially commercialize them, those products themselves? Again, sort of scoping of the removal, and then any sort of like exclusivity, right? Like anytime we're talking about sort of like licensing, like does maybe we give the customer, or the AI service provider gets rights in the IP that they develop in a certain field. And then what about trade secrets? We'll talk a lot about trade secrets later in this presentation, and who, if the AI service provider is sort of developing better algorithms, better models, who gets to sort of own those trade secrets that come out of those relationships. So that's sort of on the structuring point. That's what we see sort of like, from a structuring deal standpoint. There's also sort of economic considerations, and I won't spend a lot of time on this, but like just sort of like basic kind of economic considerations for any sort of, customer arrangement that you might deal with in this space. So the first is, again, if we're talking about IP ownership and licensing, if the AI service provider is going to be licensing out sort of the compound, are there upfront payments? Are there milestone payments? Are there royalties, meaning sort of, you pay sort of a percentage of the revenue that's generated based on the IP? And then what about costs? Is there going to be some sort of reimbursement? Or is the AI provider just sort of a service provider, in which case usually there's sort of an upfront fee, maybe a fee for the services performed, maybe sort of a payment upon delivery, and then, again, reimbursement. And then the last thing that we kind of think about sometimes is sort of like when you're doing these transactions, sort of making sure that, these transactions usually are not sort of a one-time thing. Like many times these AI companies that are sort of acting on molecules or working with life sciences companies are going to do many of these transactions. They're going to work with many customers. So thinking through, who owns the data, the results, the insights, from the platform. Again, thinking about exclusivity, Are you going to provide sort of all of the candidates that you developed using your algorithm to your customer, or or are you going to hold some of those back? And then we've already sort of talked quite a bit about sort of the ownership of the IP. And then if you're a life sciences company, right, and you're working with one of these AI service providers, again, thinking about what do you want to get back from the AI provider? Again, think about exclusivity rights from that perspective, and again, who owns the IP at the end of the day. So that's kind of we wanted to start with kind of like the big picture, right? Like why, if you're a company that's sort of, building software and working with life sciences companies using AI to help sort of develop biotechnology innovations, those are kind of the big level, ultimately picture, considerations that come into play when you're dealing with transactions and with your customers. But obviously, a lot of what I said there had to do with sort of like figuring out who owns the IP and what type of IP. And so it's really important to be thoughtful when you're building a company that is sort of at the intersection of AI and life sciences to think about what is the tool that like I'm going to use to protect, these particular buckets of IP. And the life sciences space has historically been very patent heavy, and there's good reason for that. Olivia's going to spend quite a bit of time over the next few slides talking about sort of what patents are and why they're important, and frankly, why the life sciences community has valued them for so long. But we put this slide just to remind you that there are many types of IP, many different ways that you can protect your technology, and patent is only one of those tools. And so then once Olivia is sort of done kind of walking us through what patents are and why they're so important and why you might want to have them if you're in this space, I'm going to touch a little bit on some other types of IP that are also very relevant, particularly when it comes to the AI side of these technologies. Olivia, over to you.
Excellent. Awesome. Okay, so the first kind of IP tool that we're going to talk about is patents. And the one thing about patents to keep in mind is if you're in the AI space and you're going to start partnering, licensing, or doing any type of business with third parties, you have to think about how you're going to protect the inventions that you guys have. And so one of the mechanisms by doing that is doing a patent. Now, a patent doesn't fit all situations. And so this is why you kind of want to think about the interplay between patents and trade secrets. But let's start with what is a patent. So a patent really is, at the high level, it's a social contract between the patent owner and the government. So if you disclose your inventions in a patent that is then published and available to the public, the government is going to give you a time-limited monopoly to that invention. So there are a couple key points about patents that you should really keep in mind in this space. So first, a patent is really just a right to exclude others from practicing your inventions. And they're limited in time to only about 20 years, and they're also limited in geography. So a patent issued in the United States has no rights or kind of any power whatsoever in like Canada or Mexico. Also, there is no patent police out there. If someone is using and then infringing your patent, you have to go sue them. Next slide. So the main components of a patent at a very high level, there's always the front page, and the front page has like all your kind of nuts and bolts and information about the patent itself. So like they'll have like the title, who the inventors are, who the assignee is, the filing date, etc. Now, the bulk of the patent, if you look at a patent, sometimes they're like 20 pages and sometimes they can be like 500 pages long. And the bulk of that patent is something called the specification. And this is like the public disclosure. And anything you put in that specification is eventually going to be published, that your competitors are going to know, your clients are going to know. So sometimes this is the one thing about patents that we really keep in mind in this space. Lastly, the next big piece of a patent are the claims. Now, the claims are the most important part of a patent because the scope of the claims determines what you can exclude others from. So it doesn't matter if you have all these great details in your specification. If they're not in your claims, you can't use them to exclude others. Next slide. So to get a patent, you have to meet certain statutory requirements. So first, the invention must be directed to patentable subject matter, and it must have a utility, meaning that it has to have some type of use. So for example, you can't patent a sheet of music or a book. You also couldn't patent compounds that have no use, because if you just file the patents on compounds, the USPTO is going to be like, well, what are they useful for? What do they do? And if you're like, I don't know, we just had an AI model generate all these compounds, we don't know what their use is, you're going to have a hard time, because an examiner is going to go, you haven't shown that your invention is actually like useful or has utility. Now, the second requirement is that inventions have to be new or novel, meaning that if the invention is already being sold or is used in the market or it's described on a website, you can't get a patent. Third, it must be non-obvious. And fourth, that specification, that bulk of the patent, must be able to describe the invention and then enable someone to make and use that invention. That's kind of the whole point of that social contract with the government, right? It's like you disclose it and then you get this monopoly. Next slide. So there is a process at the USPTO to ensure that these patent applications comply with these statutory requirements. I have to say, though, I look at some claims that come out of the USPTO and I'm like, how in the world did an examiner allow these claims, right? They're so broad, or they're completely, not enabled or something. So that's another issue. But at a high level, it is assumed that going through this patent prosecution process, that the claims that issue in a patent application comply with all those statutory requirements. So what happens is that an examiner at the USPTO reads the patent application, reads the claims, and then determines that the invention is described, that the claims are novel, and that the claims are non-obvious. Now, if they are, the application is granted as a patent. If not, then the examiner issues something called an office action. And this is what Marty and I spend a lot of our time doing, is then we counter the arguments raised by the examiners. So it's kind of like a negotiation. The examiner says, hey, these claims are obvious. And patent attorneys like me and Marty say, no, they're not obvious. And here are the reasons why. And we push those arguments. And so eventually, once we get the examiner kind of convinced that the claims comply with all the statutory requirements, it issues as a patent. Next slide. So there are critical steps in an application process that undergoes to be issued as a patent by the USPTO. So first, and I think it's the most important part, is the strategy. The strategy has to be mapped out. So for example, in the AI space, there are usually strategic discussions about whether a patent application should even be filed. Sometimes we look at stuff and we're like, you know what, this is more trade secret level. We don't want to put it in a patent because it's eventually going to be disclosed. And also, what should be patented? And is it going to be the AI algorithm itself? Is it going to be the outputs of the AI model? How does that work into your whole business plan and how you're going to protect your streams of revenue? Like, we want to make sure that the patent applications that are filed are strategic in your overall business model and about how you're going to be deriving revenue. The other thing is, who owns this patent application? So once we go through all these strategic discussions and we kind of define a strategy going forward, the patent application is then drafted to comply with all the statutory requirements, meaning utility, novelty, non-obviousness, written description, and enablement. The patent application goes through this examination process at the USPTO, and if the requirements are met, it issues as a patent. Next slide. So remember how we talked about patents are limited in time and jurisdiction. So let's look at a very simple example of how a single patent application can lead to several patent applications that are pending in several countries. So let's say that we filed a provisional application in January of 2024. Now, in 1 year, you kind of have to decide what to do with that patent application. If you do nothing, then it just dies at the USPTO. It's never published, and it's like it never existed. And believe it or not, like, we have a ton of clients that do this. Like, they're like, oh, we got this great new data, or we got this great idea. and we hurry up and we file a patent application. And then a year later, it's like, yeah, this didn't go anywhere. Like, this is not valuable. Like, just let it die. Just don't let it publish like it never happened. And that actually happens pretty often. Now, if you want to pursue protection for that invention, then you either file a international patent application called a PCT or a US patent application. Now, that international patent application then must be entered into several different countries a little time later. And if those patent applications issue as patents, then pretty much this whole patent family, kind of everything that stems from that first patent filing, would expire in about 2045. So as a rough guide, it's 20 years from the filing of your PCT application. So one more thing to notice, 18 months. This is a very critical date. 18 months from your earliest filing date, that PCT application and those US applications, they're going to publish, which means your competitors, your potential competitors, people that want to know what you guys are doing and how to knock it off, they're going to have access to all that information that you disclose in your patents. And so that's one of the considerations about, do you patent or do you keep something a trade secret? Next slide. So getting a patent application to issue as a patent is actually not a trivial matter. But if you can clear this hurdle at the USPTO, then a patent is issued. Now, remember, there is no patent police. Like, you are the patent police. You have to go out there and sue someone. You have to assert your patent against an infringer. And when you do that, your patent also must be able to survive certain challenges that it might face in the courts. Next slide. Now, many patent applications that are filed actually never issue as patents. They just kind of die at the USPTO. And it's because the claims did not comply with the statutory requirements. And so sometimes the patentability hurdle, just to even get something out of the USPTO, just can't be cleared. Next slide. Okay, so one of the main reasons that claims do not comply with Section 102, that novelty requirement, is that if the invention was already described in a printed publication, then the patent will not issue. Next slide. And believe it or not, this happens, it's magic, this always happens, is that one of the main reasons is from self-inflicted prior art. So this is where a company describes their invention in a press release or in an investor deck or on a website or in a journal article before the patent application is even filed. So the biggest threat to a patent is a prior disclosure. So Marty and I deal with this space all the time where they're like, oh, we forgot a press release is going out tomorrow and we need you guys to file a patent application on this. Or we are now going to be pitching for this new fund. And so here's our deck and we want to disclose this invention. Can we get something on file very quickly? So a lot of times, like before something is released to third parties, you want to patent it, because if it gets out there, then you can never patent it again. And so this is another consideration about whether you do patents or trademarks and how you might have to disclose them to a third party. Next slide. And then the second biggest reason is obviousness. This is usually really squishy. Examiners at the USPTO think everything is obvious. And patent attorneys like me and Marty believe that nothing is obvious. And so it usually comes down to, can we convince examiners that the invention is non-obvious? Next slide. Okay, so let's assume that you get a patent application to issue as a patent at the USPTO, and then you learn that someone is infringing your patent. Next slide. So remember, there is no patent police. They are not self-enforcing. You are the patent police. Next slide. So to enforce your patent, you need to sue them, the potential infringer, whether it's an inventor, whether it's a company, wherever. You need to sue them in a court in the United States. And this brings in another challenge to your patent. And the question is, will your patent be able to survive a challenge in the courts? Next slide. So if you sue someone for infringing your patent, they can countersue you, and they can basically assert to the court that, hey, this patent is not even valid because it does not comply with the statutory requirements. And so they can say that the claims are, they're not novel, they're not, they're obvious, they're not adequately described, whatever. Now, if the court or the jury agrees that your patent claims do not comply, then it could be found invalid. And then you can't enforce them anyway because your patent is dead. Okay. So even if you get a patent to issue at the USPTO, a court later on could find that your patent is invalid for failing to comply with the statutory requirements. But a court could also find that your patent does comply, and it could survive a challenge in the court. And then if the infringer is found to infringe your or your patent, then you could be awarded damages for them infringing your patent. Next slide. So patent litigation is the kind of the patent police process. But as a patent holder, that you have to go out and enforce your rights. Next slide. So if you're deciding to use patents to protect certain aspects of your business, there are certain things that you must keep in mind. First of all, patents are published, so your competitors are going to see and going to know what you're doing. Patents may not issue. You may file a patent application and you can just never get over that hurdle of patentability. So you may not even get a patent out of it. And then the third one is that you have to go out and enforce them. So it can be a very costly process, but once you have them, then you have to go out and sue people to get people to comply. And Marty, I'll turn that back to you.
Awesome. So, okay. So remember, sort of we're kind of phrasing this presentation around if you're a company and you're developing technology sort of at the intersection of AI and life sciences, what is the right sort of tool in the toolbox? So as you just heard from Olivia, lots of benefits to patents, right? It is a exclusive right. One thing that we're going to talk about trade secrets is that it doesn't matter if somebody, there's no sort of defense. If somebody's infringing your patent, there's no sort of defense. You have sort of this exclusive monopoly, but it's time consuming. You have to do quite a bit of work to sort of enforce them. And what Olivia didn't mention, because she's a very skilled attorney, and we're never that out front about this, but patents are incredibly expensive, right? So patents cost a lot of money, not only everything that she mentioned there about securing a patent and enforcing a patent, all of that costs money, not only in government fees, but also in lawyer fees. So for certain types of technology, you may want to consider other approaches, right? What's another approach? So another approach is a trade secret, right? So a trade secret is, it's different than a patent, right? It extends to a broader array of information. It's got to have some competitive value, and it's basically anything that you treat as confidential, right? So a lot of people like there's no real application process for a trade secret. There's no people say, well, what's the process for getting a trade secret? It's not complicated. You just keep the stuff secret. That is your strategy. This thing has value to me, and I'm just not going to tell anybody else, how to do it. There's some basic requirements, it has to have some sort of competitive advantage, but most things sort of, that people consider trade secrets will sort of meet that bar. And some classic examples of this are manufacturing processes, techniques for doing different assays, and critically, software, right? A lot of people choose to keep software code as a trade secret rather than going through the patenting process. But here's the rub. It only protects against actual copy. So what that means is if you make the decision, you say, you know what, I've got this software. It's a really interesting algorithm. It's been trained on a bunch of, really interesting data, and it gives out really great results for, whatever sort of output you're interested in. But the patent process is really difficult. I don't really want to spend the money on it. And I don't also want to tell people exactly how my software works, because if I put it in a patent application, as Olivia told us, it's going to end up becoming public knowledge. And I'm not even guaranteed when it becomes public that I'm going to actually get my patent on it. So I'm just going to keep it as a trade secret. That's fine. But one of the big differentiating factors between trade secret and patent protection is that for trade secret, independent conception is a complete defense. So if somebody else comes up with the same thing that your software does independently of you, right? Like they never had access to your software code. They didn't actually copy it. They just independently sort of came up with the same thing that you came up with. If you had a patent on it, you can stop them. If you decide to keep it as a trade secret, they're completely free to do that. You cannot stop them. So that's a big difference. If you do, so why this sort of comes up, just before I get into sort of like some trade secret tips, why this comes up quite a bit, in why this hasn't historically been something that life sciences companies have pursued much, is that this is only really an option for something that you can keep secret. If your technology is like reverse engineerable, like if you have a mechanical device and you put it into the world, or if you put a drug into the world, that's reverse engineerable. Somebody can take it apart or put it under a microscope or whatever and figure out sort of like what's in it. This is really only an option for stuff that is not reverse engineerable, and that includes software. So if you do choose to protect your technology with a trade secret, you want to sort of employ strategies that are going to maximize your chance of success. The first is, all right, you have to keep the code secret. How do you do that? Well, first of all, anyone that has access to the code should sign an NDA and be sort of at least under a contractual obligation to maintain that code as secret, at a minimum, right? If you don't put them under an obligation, then you're not doing anything to keep the code secret. Another thing to do is to be very cautious of open source issues. Now, I can give an entire hour-long presentation on open source. I won't do that here, but suffice to say that in the software space, there's all sorts of software code that's available out there for free. Anyone that's developing software knows this. There's all sorts of GitHub libraries with free code. And in some ways, that's great because we don't really want people recreating the wheel if they're creating some very simple software algorithm that many people have written before. It can be nice to be able to just use an existing software code to sort of plug into your code base. But keep in mind that that code is always made available to you under a license, usually an open source license. And there are some good open source licenses which basically say you can use this code for free, but any modifications that you make to the code, you're allowed to keep as secret. Then there are bad open source licenses, which are called sort of copyleft licenses. And what they say is you can use this code for free, but then you agree as a sort of condition of getting this code for free that any modifications that you make to the code, you must also make available for free. So again, if your whole strategy is to keep your code, your software code, as a trade secret, if you are incorporating into that secret code software that you are licensing under a copyleft model, which now says you need to make that code publicly available, you're not doing a very good job of keeping the code secret. So that can be a big sort of problem, and you can blow your whole trade secret protection strategy. Then the last, good cybersecurity protections. That one of the things about a trade secret is once it gets stolen, or once it gets like sort of put out into the world, you can never sort of keep it secret again. What you have in that instance is you have a cause of action against the person that stole your trade secret, but you don't get to maintain the trade secret. It's now out in the world. So, you want to prevent sort of, hackers or something from stealing from you, because then you lose the trade secret. Another big consideration is employee mobility issues, right? One of the biggest sort of weaknesses that you have against trade secrets is employees that you employ that have access to trade secrets and then go to another company. So, you want to make sure, actually the second bullet there, that, you sort of protect, your employees when they go somewhere else from not bringing trade secrets with them. You also want to be conscious when employees are joining your company that they're not taking trade secrets from another company that they were at and bringing them to you. Okay, that's trade secrets. Now, this can be confusing sometimes because in addition to trade secrets, right? I just described like what a trade secret is. Like it's basically just something that you keep secret, right? And I said much software code is considered to be trade secret. It's kept secret. At the same time, even though it's maintained as a trade secret, another tool that covers software, it covers the same software, is copyrights. So a copyright protects any work of authorship that's fixed in a tangible medium, and then a bunch more words that don't really matter all that much, but this is sort of the legal definition that sort of we put on the slide. But it's basically any creative work. And many people, I think, are familiar with that with sort of like a photograph or a painting or, a drawing, but it applies to software code as well. So anytime that software code is written, the moment that it's created, one of the benefits of copyright is even though you can register it, and sometimes people do register their copyrights, particularly in advance of litigation, you have those rights. You have copyright in your software the moment that you sort of write it. And what it does is it protects, prevents against other people from copying that code. Different timelines when it comes to sort of employees, but generally speaking, they like expressions of the idea. They don't protect the underlying idea itself. So what you have with the copyright is it protects against somebody straight copying your code, but it doesn't protect if somebody understands the idea of what your software code is trying to accomplish. They could write their own code to accomplish that idea, and they would likely, be able to sort of avoid infringement of your copyright. All right, Shantanu. Yeah, so that's right. So Shantanu asks in the chat, like, what about code that's actually generated by AI itself? The basic takeaway on that, and this is actually true for patents as well, is the courts have actually been pretty clear on this, and we could do a whole presentation on this as well because it's kind of an interesting body of law right now. But it's a statutory thing that AI computers cannot be the author of a copyright. Same is true when it comes to patents. AI cannot be the inventor on a patent. So if the code is actually written by AI and the creativity aspect of the code comes from AI, it cannot be protected by copyright. Now, much code that's written these days with tools like sort of like Copilot and things like that, it's sort of an assisted, it's assisting sort of the code drafter, it's sort of finishing off lines for them. So many companies, and we give this guidance, take that position that in that instance, the AI is really just sort of a tool that is helping the real author, right? It's kind of like a camera, right, is helping a photographer. The photographer still owns sort of the picture that they take, but certainly at a certain level along that, bandwidth, if the creativity or the inventiveness is coming from the AI itself, you cannot get a copyright on it and you cannot patent it. Okay. Yeah, so again, just sort of avoiding copyright, problems. Make sure, right, like these copyright things kind of go both ways, right? So you own sort of your own rights in software that you develop, but remember that other people have rights in their software, text, images as well. So, if you have sort of somebody else, create something creative for you, like draft software for you or whatever, get an agreement with them in writing to make sure that you own sort of the IP in whatever they develop for you. There's a lot of copyrighted content out there that people rip off the internet all the time, Google Images and things like that. Even though, and I put it on the next bullet, that you could consider for your copyrighted content putting a little C with a circle around it. You're certainly entitled to do that the moment that you create a creative work. It's not required to put it on there for there to be copyright. Most content that you see on the internet is protected by copyright. And again, just a warning here to be careful about open source software. All right. So now we've talked through patents, we've talked through, trade secrets. Let's just kind of boil it down, right? Like if you're a company and you're developing technology, right, what is sort of the right tool for you to protect your asset? And by the way, it doesn't need to be one for your entire company, right? Many companies have some things that they protect with patent and other things that they protect with trade secret. Remember, for a patent, this is just kind of summarizing what both Olivia and I said earlier, but for a patent, if somebody else independently invents it, you still have exclusivity. You have to make the idea public. You've got a limited term, and you got to prepare and file a patent application, and you got to go through some work to enforce that patent, which, read $, that costs money. With a trade secret, if somebody else independently invents it, you got no recourse. But The idea remains a secret. There's no term. It potentially lasts indefinitely, and there's no filing required, which means it's significantly less expensive. So here's one construct that you can sort of think about. This doesn't apply to every company, but sort of one construct that you can sort of think about, right? So just a way to sort of start organizing your thoughts that I sort of talk through with my clients. So a lot of times I ask my clients to sort of start about what are things sort of about your product that customers like, right? Like what is driving customers to use your product, right? Is it the speed that is it the effectiveness of it? Is it the efficiency of it? Is it, what is it, right? Is it, if it's a drug, right? Is it, what about your product is driving customers to work with you? Then of course there's going to be things about your product, right, that people may like that you didn't invent, that you didn't sort of like independently come up with yourself, right? So there's going to be sort of a subset of things that customers like about your product that you can own. And that's sort of the intersection in both yellow and red there. And then you want to think about, okay, now I've got sort of this subsection of things that I kind of came up with, that I invented, and there are things that people like about my product. Now, which of those things can you detect? We didn't spend a lot in the earlier slides talking about this, but again, one of the drawbacks to a patent sometimes, particularly for software, is you can't necessarily know what somebody else is doing in their software if it's housed behind some secure server somewhere, right? So what of this subset of things can I actually detect that somebody else is doing, and can I actually sort of enforce my rights against? And then those things that you can detect and enforce, likely worth patenting or worth considering patenting. The other stuff, maybe you keep as a trade secret. Just one construct, one thing that we sort of think through with our clients. And then, just sort of reciting a lot of the same stuff here, but, factors to consider. Is secrecy even an option, right? If I'm looking at my technology, again, if I'm selling a drug, if that's what I'm selling, that secrecy is not an option. Somebody can take that thing apart and figure out what's in it. Not to mention, you usually have to go through some sort of a regulatory process where you got to disclose to all manner of government agencies sort of what's in the product. A lot of biotech inventions are reverse engineerable, and if they are, probably leans towards patent. What are the chances of a patent being granted? Olivia walked us through sort of all the different hurdles you got to clear. If you're not going to get a patent, why publish this thing? Likelihood of independent invention, right? Is, like I said, if somebody else comes up with the same thing that you did and you don't have a patent on it, you're just keeping it as a trade secret, you got scooped. Somebody can take what you're doing and do it as well. Detectability, I just talked about that a little bit. And then the last thing is speed of invention, right? So for a lot of life sciences companies historically, right, with a drug, that 20-year term is a big deal, right? You get a patent for 20 years, you can keep people off the market for 20 years. That's really important. But in a lot of software spaces, if this whole technology space is going to be irrelevant, like if they're going to move on to a different type of code or a different type of algorithm in 2 years, well, Olivia showed you the length of the patent process. The patent process itself takes longer than that to kind of play out. So you also want to think about how fast is the technology, in this space moving. And I will hand it back to you, Olivia, to talk about just a few more considerations for AI and life sciences.
Yeah, we have some examples we can walk through about how we're seeing AI kind of come into the life science space, kind of that intersection. But also, if anybody has any questions, happy to take them now. Otherwise, we can walk through some of these like examples, what we are seeing. So type up if you have any questions or drop them in the chat. Happy to entertain any questions that you have. So one of the things about, like Marty touched on in the life science space, is that usually you have a drug, whether that's a small molecule, an antibody, some type of therapeutic, either a medical device, something that has to go through the regulatory pipeline. It has to go through, preclinical studies. It has to go through a phase 1, which is done in humans, phase 2, where you're seeing if it's actually has efficacy. Phase 3 is kind of your full blown, and then if you get approval. The problem with this pipeline is that it's expensive. It's estimated that it costs between $1 and $2 billion to bring a drug to be approved by the FDA. So if you have small molecule, if you have an antibody, you're looking at $1 to $2 billion to get that approved by the FDA. It can also take 8 to 15 years for this entire process. And also the likelihood of success is incredibly low. We're looking at 10% of drugs that enter the clinic actually get approved by the FDA. So this process is long, it's expensive, and it's just fraught with challenges and fraught with failures. So one of the hopes has been, how can we bring AI to kind of increase this, like either increase the likelihood of success of having a therapeutic actually be shown to be safe and effective in treating a disease, and how can we shorten this process as well? Next slide. So a great example of this is BioAge Labs. So BioAge Labs has an entire platform, like an AI platform, where they really kind of sifted through all this data. And by using their AI platform, which they keep as a trade secret, they do not patent this, right? So they discovered kind of an old small molecule that Amgen had originally developed for heart failure. And it was taken into a phase 1, shown that it was safe in humans, but they just kind of dropped the program for whatever reasons. Well, through their AI platform, Biogen actually identified that this molecule might be useful in treating certain metabolic diseases. So currently, this old Amgen molecule, this old compound, is in a phase 2 trial for treating obesity. So we'll see if they get through a phase 2 and through a phase 3, and we'll see if this kind of test of repurposing old drugs and then finding them out would be great. Oh, here's a question. Some broad molecule claims in patent applications are eventually not be granted. Let me see. Will these claims become prior art to others? So the interesting thing about broad patent claims, right, is like it's meant to, like, you want to cast off everybody and say, hey, stay out of my space. You know, this is what we're working on. The problem is that it is prior art to you, it's prior art to everybody. And a lot of them, they're just not enforceable. They're too broad. Once you get to a court's going to go, these claims are way too broad. You have not enabled all the compounds that fall within your genus, right? You're not going to get those broad claims anyway. So a lot of times, those are the types of patents that just kind of die in the patent office. They never get granted. Or what does get granted are very, very narrow claims. So what kind of people are doing right now is this whole repurposing ideas. So they're looking at compounds that were, maybe generated 5-10 years ago that just the patents just died, right? They've never got anything issued. So they have freedom to operate. They can take all this material that's in the public domain because the patents are dead. They'll take like old antibodies and they'll see about, like, can I make a bispecific? Can I make, other types of fusion proteins with these kind of like old antibodies? And so this repurposing idea is really kind of coming about, kind of what BioAge did. They took kind of an older molecule that kind of going off patent, and I think actually in-licensed it, so they got some patent term there. But the idea is, like, you take these kind of older things and then repurpose them for new uses. We can go to the next slide. There's another great example. So this is kind of like how this works with AI and kind of leveraging AI's power to get some drugs through the clinic. So a lot of times using AI for pattern recognition of given like a vast amount of data. So looking at like target identification, target validation, targeting strategies, or even just identifying composition of matter. So MIT actually, they leveraged AI. So they basically trained an AI model to identify certain chemical structures that would inhibit the growth of E. coli. So they screened like millions of compounds in this algorithm to find a novel molecule that could kill E. coli. And so once that AI model was trained, they then used the same process to target another type of kind of what's called an acetinobacterial. It's one that causes a lot of diseases in humans. So they used the same process, and they were able to screen about 7,500 different types of chemical compounds. And then they were able to analyze and kind of dwindle that down to 240 compounds that were actually identified for killing this particular bacterial strain. And they basically found a couple of very potent compounds that could kill this bacteria. What's interesting about this process is, like, they went into it not knowing how the compounds were killing the bacteria. They were just looking at what type of chemical matter killed the bacteria. And then once they identified it, they're like, okay, so how does this work? And then they had to figure out like the mechanism of action of how it actually did, and they actually figured out a new mechanism of action for killing bacteria. So it was a really interesting way to kind of leverage the power of AI to find new chemical matter and new mechanism of actions for treating bacterial infections. Next slide. There's another public company that Goodwin actually represents. So their core technologies in the space of synthetic biology, which they use for programmed gene therapies. And a lot of it is kind of like this benchtop chemistry where it's kind of done in a lab doing traditional biology screening for drug discovery. And so they started identifying ways that they could use AI to kind of really accelerate this process. So really accelerating that R&D and kind of trying to find lead candidates. And, you know, the advice kind of was given to keep that platform as a trade secret, because the primary concern, as Marty touched on, is like detectability and enforcement. How do you, if you had a patent on this technology, how would you detect if a competitor is using it or not? Most likely you wouldn't. So it's the idea is, instead of disclosing it, just keep it as a trade secret and then use that as a way to protect some of your assets. So we're the pattern recognition power of AI is becoming really important in the vast amount of clinical data that we get. So the amount of, when you run a clinical trial, depending on how many patients you have, there's all these different parameters that are measured. There's all these different, outputs and inputs into the clinical trials. And so being able to use pattern recognition to analyze certain clinical data sets to kind of really understand what happened. So if you run a clinical trial and the drug works, well, no one cares about this, right? It works. Let's just move on. Let's move on to phase 2. Let's move on to phase 3. Let's get approval. Where this becomes really important is when a drug fails, to understand why it failed. So, because a lot of times what happens is maybe you didn't have the right patient population. Maybe you didn't have, the right dosing regimen. But if you could use AI to use these types of things to identify these types of problem areas, then we might see a higher success rate of drugs that actually enter the clinic. And so that's kind of our end result. We kind of talk with our clients, Marty and I do, and we counsel about how to kind of weave together patents and trade secrets to overall protect this kind of intersection as AI is moving more into the life science space. Marty, do you have any concluding thoughts?
No, that's pretty much it. I guess here I'll just stop sharing the presentation. Just kind of where we started at the beginning, like, Olivia and I sort of work with companies as we just kind of talk through on these kind of issues every day. So if anyone is building a company or you start building a company in the future and, you need some guidance on this, the one thing we didn't put at the end here was sort of a slide with sort of our contact information, which we probably should have. But lawyers are very easy to find. So if you just Google, either of us, you'll find sort of our email and our phone numbers, and we'd be happy to chat with anybody about any of these issues, if you're confronting them now or at some point in the future.